Ladies and gentlemen, welcome back to the Indie Zone podcast. My name is Kathy. On the 24th of April, 2025, Judge Hippler rendered an order on defendant's motion to strike the DP regarding autism spectrum disorder. Now, you'll recall last year in September, at about the time the change of venue was granted, Mr. Kohberger filed numerous motions to strike the DP on various grounds, all of which, after briefings and oral argument, Judge Hippler denied. So this motion was filed after Mr. Kohberger's recent diagnosis with Autism Spectrum Disorder, ASD, is indicated in the introduction section, first line. Defendant seeks, according to this order, to strike the DP as a sentencing option, arguing it violates his constitutional rights, specifically what he argued, Eighth Amendment, cruel and unusual punishment prohibition. He contends ASD is the functional equivalent of an intellectual disability, which is categorically recognized as a disqualifying exemption to the DP. So what the defense was arguing here is ASD is the same as an intellectual disability, which is categorically, that means it just gets thrown out the window, the DP, if a defendant can prove an intellectual disability. Even if the court rejects a categorical approach, he argues the DP option should nevertheless be stricken in his case, given the intense media attention on defendant's disability. So he's giving a second reason here why, according to the defense, the DP should be thrown out. Next paragraph. In response, the state disputes that ASD is equivalent to an intellectual disability for purposes of a categorical exemption to the DP, and further notes that defendant has not shown a national consensus supporting such an exemption. As for defendant's individualized argument, state contends that none of defendant's concerns warrant striking the DP. The court continues. Oral argument on the motion was held April 9th, 2025, after which the court took the matter under advisement. What does this mean? Advise who? When the court says this term, it means he is taking all of the briefings, the motion, the response, the reply regarding striking the DP on the grounds of ASD, and what both sides argued the day of the oral arguments back on April 9th. Having done so, here's the ruling. The court finds striking the DP is not warranted, so therefore motion denied. Now, if you look at this filing, you will see over the next several pages where the court goes into the background, gives the law, applies the facts to the law, and then finally comes to his conclusion, which we already know by reading page 1. But his conclusion, his ultimate ruling, is here also, page 14, section 5 order, where Judge Hippler writes, based on the foregoing, the defendant's motion to strike the DP regarding autism spectrum disorder is denied. It is so ordered, dated the 24th day of April. So what has effectively happened is the state has withstood another attack on the DP. The DP is still on the table in the event of a conviction. What would happen then is matters would go into the second stage of the proceedings, and the issue on the table would be, what should Mr. Kohberger's sentence be? We always must remind ourselves, however, that he is considered innocent of all charges until or unless one of two things happens. He pleads guilty or is adjudicated guilty following trial, which is set to commence August 11th, 2025. Thank you for joining us here today.